Good afternoon, and welcome to today's NHLBI Small Biz Hangout, Patent Litigation, Basics, Defense, and Offense, Part 1. With today's presenters, Drs. Gautam Prakash and John Shu. I'm Chris Paciella, and I'll be the moderator for today's event. Next slide, please. If you're just joining us, you can join in our event either of two ways. You can click the call-in icon on your screen, and that will play the audio through your computer speakers, or you can call in by phone using the number indicated both on this screen and included in your registration confirmation email. Next slide. Before our experts start talking, I want to make you familiar with the NHLBI Small Biz Hangouts. These webinars have been created by the National Heart, Lung, and Blood Institute's Office of Translational Alliances and Coordination to provide biomedical innovators with basic information about the knowledge areas that they didn't learn while they were studying science in their schools. Things like regulatory considerations in your technology space, understanding how to identify, describe, and reach your market space, and how to approach developing and maintaining an intellectual property portfolio. The Hangouts are recorded, captioned, and then archived as a playlist on the National Heart, Lung, and Blood Institute's YouTube channel, and they are accessible at the link indicated on this slide. Next slide, please. All attendees are currently muted, and you'll remain so throughout today's presentation. We do, however, encourage audience participation and ask that you pose questions as they occur to you by typing them into the chat box in the lower right-hand side of your screen. Your questions will be visible only to the presenters, so you don't need to be concerned about colleagues being able to attribute questions to you in particular. Also, just to frame the conversation, we're only able to answer questions that are both general in nature and related to the topics presented in today's event. We appreciate your understanding that answering very specific questions would require an in-depth discussion and is inappropriate for this particular venue. If you do have specific questions, you can reach out to the presenters after the conclusion of today's event. To get a copy of today's slides, please provide your email address in the brief feedback form that you'll receive at the conclusion of the Hangout. Next slide, please. Today's presenters are Drs. Gautam Prakash and John Shu. Gautam has been working with the NHLBI Office of Translational Alliances and Coordination for about 18 months. He has more than 13 years of experience as both a patent attorney and a patent examiner at the U.S. Patent and Trademark Office. Currently, he is on detail with the NHLBI as an intellectual property advisor to our awardees. Dr. John Shu has more than 15 years of experience as both a trial and appellate intellectual property litigation attorney. He's currently a partner in the Intellectual Property Practice Group at Schiff Hardin, LLP, and is a long-term colleague of Dr. Prakash. We're very much looking forward to hearing from both of these esteemed gentlemen during today's presentation. Next slide, please. At the end of today's event, as I mentioned, these events are archived. We continue to build the series, and our next Small Biz Hangout will occur on October 13th at 2 o'clock in the afternoon Eastern Time, and will be focused on how pharma evaluates new therapeutic opportunities. Dr. Gary Robinson, the Business Development Specialist at the National Heart, Lung, and Blood Institute, will host Dr. Craig Wegner of AstraZeneca Pharmaceuticals. No one chooses to spend their time or resources on a project that's destined to be unsuccessful, but 99% of innovative project ideas will indeed fail. While trial and error is a fundamental component of scientific investigation, recent retrospective analyses of biopharmaceutical project failure have determined that in at least 50% of cases, failure could have been predicted prior to experimentation. The objective of this Hangout will be to identify some of the most common causes for biopharmaceutical project failure, how they can be recognized, scored, and potentially worked around before they occur. Next slide, please. If you need to leave today's Hangout before its natural conclusion and you'd like to request today's slides, please send us an email at NHLBI_SBIR@mail.nih.gov. Next slide, please. And finally, I would like to note that if the Small Biz Hangouts are organized and presented by the National Heart, Lung, and Blood Institute's Office of Translational Alliances and Coordination. If you are developing a product or technology within the NHLBI mission space, which covers cardiovascular, pulmonary, hematologic, and sleep disorders and diseases, please contact us through our website listed here for additional assistance in your technology development work. If you're developing a product or technology outside of our mission space, we encourage you to please reach out to a program official in the appropriate institute at the National Institutes of Health for additional assistance. A list of these contacts can be found on the SBIR website for NIH. And now, I'm very happy to pass the presentation over to my esteemed colleague, Dr. Gautam Prakash.
Great, thanks, Chris. Let me get this video here. So the only thing I'll add to that wonderful introduction is, as Chris mentioned, John is not only our patent expert for today, but he is a friend and colleague for over 20 years. We went to the University of Maryland together, doing our PhDs in chemistry, and later worked together professionally. And it's a pleasure to have him here as an expert. I'd like to personally thank him for donating his time and expertise to this webinar. So let's, for those of you who've been following this series, know that this is the third in our intellectual property themed Small Biz webinars, and the first one was on intellectual property basics, the second one was on trademarks, and as Chris pointed out, you can find both of them archived on the NHLBI YouTube channel, the bit.ly link being bit.ly/Small Biz Hangouts. In the past two webinars, in this two-part webinar, we shall look at patent litigation, and in part one, which is today, September 8th, we'll look at some basics of what patent lawsuits are, what does one mean when one talks about infringement of a patent, and also about patent validity. And then we'll look at how a typical patent lawsuit would occur and where it would occur. In part two, which will be on November 10th, 2015, we'll look at patent litigation of the United States Patent and Trademark Office, patent litigation as a patent owner, as opposed to infringer, and as part of that, we'll look at expert witnesses, which is a very key part of patent litigation, as we'll find out. So we have the obligatory disclaimer. This is only for educational purposes. It's not designed to provide legal advice. In other words, please don't expect you're going to be able to go out and litigate a patent case after this presentation. As we'll see, patent litigation is really highly technical and complicated and frankly unpredictable. All the views expressed are those of the presenters. John and myself do not represent the views of the Heart, Lung, and Blood Institute, National Institute of Health, the Department of Health and Human Services, the U.S. government, or of Schiff-Hardin LLP. So I am now, with the disclaimer over, going to turn it over to Dr. John Hsu to tell us what patent infringement is.
Thank you, Gautam. Well, what is patent infringement? Well, first, you need a U.S. issued patent from the United States Patent and Trademark Office. And once it gets issued, the patentee, the patent owner, will go after an accused device or method that he or she thinks is infringing his patent. So patent infringement is the making, using, offering to sell, selling, and importing into the United States of any device or method that is covered by a patent without permission, without a license of the patent owner. Now, what does that mean exactly? Well, patents have a front page, and it has this, information on it about the number and when it was filed, when it was issued. It has figures to it, typically, and then it has a description called a specification. And at the end of the patents, you can see there's things called claims, and they're numbered. These numbered claims define the boundary of the patent, the property right that the patent office has given the patentee, and they're like a fence around a property. And the accused device or method must fall within the boundary of that patent, within what the scope of the claims define. So the claims themselves are usually broken down into elements. To infringe a patent, the accused device or method must perform each and every element of one or more of the claims, and that's considered what's called direct infringement. Or the accused infringer has encouraged someone to sell or offer to sell a component that leads to another person's infringement. That's called indirect infringement, and we'll discuss that further as we go along. but the key point here is, defining the scope of the claims and then comparing that scope to the accused device. So a classic example for a claim could be a hammer comprising a head and a handle. So there's two elements, a head and a handle, and you would compare the accused device and see whether it has a head and a hammer so that it falls within the claims of the scope of the claims. So as far as how a patent infringement lawsuit process gets started, it typically gets started by the accused infringer receiving a demand letter or an invitation to obtain a license, and we'll take a look at some typical language of those letters in the next slide. But what happens? The accused infringer needs to determine, do they agree with the terms of the letter? If so, then they could negotiate a license to be able to use the patent, or they could stop doing whatever they're doing that they're being accused of infringing the patent, or they could change their design, and that's called designing around. So they could design around the claim so that they fall outside the scope of the claim. If the accused infringer doesn't want to agree to the terms of the letter, then they could argue either that they're not infringing the claims or the claims are invalid. So ultimately, this is something that you have to determine if it's successful. Ultimately, a court is the one that determines whether there's infringement or invalidity. But if you are successful, then there's no infringement, and if you're not successful, you would be found to infringe. So as I mentioned, there are some examples of typical language that you get in these kind of demand letters, cease and desist letters. The strong type of language would be, I have a patent right and your product or process infringes my patent, immediately stop the production or sale, or I'm gonna come after you for patent infringement. That would be a strong language. That's not as typical. Usually you see soft language, which is, I have some property rights, I have these certain patents, we want to further discuss you licensing these patents in order to be able to continue to do what you're doing. When it comes to a letter, these letters will come from a person who invites for further contact to begin negotiations, because typically patent owners are serious about this situation. So, now, as far as patent infringement, getting into patent infringement more, there's two general types. There's direct infringement, and direct infringement is you perform all the elements of the patent claim. As I said, claims are typically broken down into elements, and your accused device or accused method performs all the elements of it. There is indirect infringement. That's the other type. So you're not directly infringing the patent because your actions themselves do not do every single element of the claim, but you're helping someone else practice or do every single element of the claims. Typically, there are two types. There's inducement infringement and there's contributory. Inducement is where you're providing a device that could be used in an infringing or in a non-infringing way, but you're giving instructions to that person to use it in an infringing way. So you're inducing another, you're giving them instructions to infringe. Contributory is a little different. You don't need to give any instructions, but you're selling a device that can only be used to infringe. So therefore, you don't need to give the person instructions. You're giving them the ability to infringe the claim by just giving them the device.
So, John, as a public policy matter, we don't want people to infringe valid U.S. patents. Maybe you can talk a little bit about how not to be an infringer of a valid U.S. patent.
Right. So there are ways, for direct infringement, like I said, direct is that you perform all the elements of the patent claim. If you're not performing every element, then you fall outside the scope of that patent and you would not be a direct infringer. For indirect infringement, you're not working with another to then instruct them to perform every element, or you're not selling a device that can only be used to infringe. So in that case, you would no longer be an indirect infringer because you're not causing anybody to directly infringe the patent claims.
Great. So what I've done is I have here like a simple illustration that I put together in which I have the patent claim represented by this white circle, which has a red border, that's being the fence that John talked about. And also in my example, I have the accused device or method, that's a solid red circle. So maybe we can just look at some scenarios to see whether we consider infringement or not. So John, let's start with the first one. I have a situation where my accused product or process lies fully within the patent claim. Would this be considered patent infringement?
Yes, it would be considered patent infringement because the accused device or method falls entirely within the scope, so it practices each and every element of the scope, and it is infringement.
Great. So I guess this is what would be a probably classic patent infringement. Okay, so the patent infringement, and what about this situation here where I've got no overlap between the claim scope and the accused product or process?
That would not be patent infringement because you're not practicing every element of that claim, so you're not falling within the scope, and you would not be found to infringe that claim.
Okay, so once again, probably classic non-infringement. Let's take this situation here, and what I've tried to represent here is that my accused product or process is doing everything the claim is doing, but some more. So it's you know, all of the circle and more. What would you say about this one? Is it patent infringement or not?
Typically, that's considered patent infringement because you are practicing all the elements of the claim. Now, you may have more elements that are not within that are simply not listed in the claim, but as long as you're practicing all the elements of the claim, then that is patent infringement. So typically, that's patent.
Okay, great. And then the last scenario I have here is where my accused device or method is substantially overlapping the claim. Would you consider this patent infringement?
No, that is not considered patent infringement. Not every single element of the claim is being practiced. So if the claim had elements 1, 2, 3, and 4, and you simply have 1, 2, and 3, then you would not be that would not be patent infringement. Okay.
So before we move on, I just want to add that this is a very highly idealized illustration. The reality, as we'll see, is that the boundaries of this claim, that red line I'm talking about, is very difficult to ascertain. So we're about 20 minutes in, so maybe we can just take a break to see if any questions have come in. As Chris pointed out, you can type the questions in to the chat box, and I will see if there are any of them here. Okay, so we have at least a couple that have come in. So one is you said that in the situation where you've got the claim and the accused product process doing more than what the claim does, and you said that may be patent infringement, which means that there may be situations in which it is not patent infringement. Maybe you can explain that a little more, John.
Sure. There's typically the way the claims are written, the accused device can have extra elements to it and still fall within the scope. The time when that isn't the case is if they use particular language that indicates that the claim only covers those particular elements or steps and no other, then that would not be patent infringement because you have extra steps or elements. Again, that's not the typical language that is used in a patent claim, but a patentee, a patent applicant, can draft the claim to indicate that only the steps or elements that they list in the claim is what's being covered. So those are the issues. Those are the situations where it would not be infringement. However, again, that's not a typical situation.
Okay, great. And then we talked about questions about cease and desist letters versus invitation to license, and maybe the strong language that you pointed out comes from the cease and desist letters, and the softer one comes from license letters. Can you give scenarios why one would receive one over the other?
The main reason is because if the language is too strong in a cease and desist letter, the accused infringer, the person who gets the letter, has the ability to run to the court and file their own lawsuit, and again, that gets invoked when the language is strong. If the language is softer, typically the accused infringer can't do that. And the patentee, the patent owner, would like to keep that in their control of when they file a lawsuit or if they're going to file a lawsuit. So that is the main reason why you would not see as strong language in a letter like that.
Great. And so there's one more here. Is there a ratio or percentage of claims being infringed that would not be considered, as a proportion of the entirety of the claim, that would not be considered infringement? So, in other words, I guess, can you quote infringe like 10% and then not be considered infringement, or is it an all or nothing sort of situation?
It's typically an all or nothing situation. That's why defining the scope is important, because that will then define what is all and what is nothing. Okay.
So I guess, just to clarify the question, thank you for that. If you haven't infringed, and John, correct me if I'm wrong, if you haven't infringed all elements of the claim, you do not infringe the claim. But once you have all elements of the claim done, it doesn't matter whether you're doing some of it, some of the claim. It's hard to describe, but if you're infringing it or not. So once you have all the elements down, you're infringing. If you don't have all the elements down, you're not infringing. Would that be accurate, John?
Yeah, that's a typically good way to describe it.
Okay, great. Thank you. So please keep them coming. We will. We have at least one more break for Q&A in the middle and one more at the end. So thank you for those questions. Okay, moving on. John, you kept mentioning a valid U.S. patent. A valid U.S. patent. Why does anybody care about the validity of a U.S. patent from patent infringement perspective?
Well, the main reason is because you can't infringe an invalid patent claim. So if the patent's invalid, infringement at that point is irrelevant, essentially, because it doesn't matter whether you're infringing or not. The patent claim shouldn't be there to begin with. So that is a very, very important reason why accused infringer would argue both, because it gives you both ways to win. But keep in mind, a patent claim, once they get issued by the United States Patent Office, they're presumed valid. So if it's a court case, they have the presumption of validity, and the accused infringer has a higher burden to prove that it's invalid. However, there are important ways to show that its patent claim is invalid. The claim invention existed prior to the date of the invention, so that's typically shown by the claimed invention was disclosed to the public. That's published in a reference, a scientific article, for example. They are typically called prior art, and so if you can show that the prior art disclosed the claimed invention, then it's prior to the date of invention, then it's invalid. The claimed invention could also be sold or available to the public prior to the invention, and that would make it invalid. Or it could be obvious in light of the existing information, in light of the prior art. So prior art doesn't exactly describe the claimed invention, but it's very similar, the description, and it would have been obvious to a person of ordinary skill in the art to come up with the claimed invention. So that's what obviousness is. Now, a claimed invention can also not be patentable because there are, for example, certain subject matters that are not deemed patentable by the Patent Office in the courts. Classic example of that is products of nature or mathematical formulas or algorithms. It's already in the public domain, and it's a part of nature. You can't take it out of the public domain. Or another way that patents can be found invalid is that the patentee, the patent owner, when they were getting their patent, conducted some kind of bad conduct to the Patent Office. They lied to the Patent Office, the examiner, at the time getting it, or they concealed relevant information or misrepresented certain relevant information. So that is another way that patents can be found invalid.
So there seems to be a lot going on here, John. I mean, is there anything that can help us to sort of cut through some of this to get a sense of where we stand?
Yeah, and as we talked about, determining the scope of a patent claim is a complicated process. So you can get a legal opinion as to the validity or infringement of patent claims. And that legal opinion will go into the claim language, they'll go into the description in the patent, it's called the specification, and it'll go into the back and forth between the patent applicant and the patent office, statements that were made during that back and forth. The legal opinion from a patent attorney is going to be helpful in determining that scope and also determining how, pieces of prior art can invalidate the patent. Now, legal opinions, they aren't required, but they're recommended. It gives you a protection, ultimately, against the charge that you willfully infringed the patent when you became aware of it, and that if the accused infringer is found to willfully infringe a patent, the patent owner can get up to 3 times damages, and it also gives helpful understanding to figure out your options as when you get a demand letter to determine how you're going to respond to it.
So, John, let me ask you this. We go get a letter. This is an odd scenario, but let's say we go get an opinion, and in the opinion from an attorney, it says that you are. I'll take 2 scenarios. One, that it says you're not infringing the valid patent because, the patent because it's either invalid or you're not infringing because your method is not infringing. Do you have to disclose that if you go to trial as evidence? Would it be helpful to disclose that as evidence of non-willfulness? And let's take the other scenario where, let's say the opinion comes back that says, yes, this is a valid patent, and yes, your product is infringing it. In that case, presumably you don't want to disclose the opinion of the attorney that says that. Do you have to disclose that at trial?
You don't have to disclose it. Opinions of counsel are privileged, so that is something you do not need to waive and you do not need to disclose. There may be reasons why you may want to disclose it. You can also disclose that the fact that you have a legal opinion but not disclose the contents. So there's different options you can take, but for the most part, usually these are not, the substance of these letters are not disclosed during the trial, mainly because they would be considered privileged information.
Okay, thank you. All right, so maybe, John, we can talk about some options when we receive one of these letters from somebody who claims that they have a patent that we are somehow being accused of infringing. Right,
so you get one of these demand letters or cease and desist or invitation to license letter. There's a number of different things you can do. You can do nothing. That's not typically the response, but sometimes you could do nothing hoping the patentee will go away. Again, patentees don't usually go away, so that's not the preferred response. Usually the more typical response is that you ask the patentee for more information. You want to get more understanding about what the licensing terms being offered, and you want to indicate that you understand the seriousness of it and you're taking the steps to determine the situation. You can also perform a rudimentary prior art search, so you're looking for prior art publications. With the internet now, it's fairly easy to take a look at what's out there as far as what was published before the date of invention. However, determining invalidity is also determining the scope of the claims, defining what those claims are, and that's not a trivial exercise. And then as we discussed, you can engage a patent attorney. You can obtain a legal opinion about validity and non-infringement of the patents that are being asserted inside the letter. And patent attorneys with the formal opinion typically conduct a more prior art search. There are firms out there that do prior art searching. And you can also file a request for reexamination. It's a Patent and Trademark Office procedure, a mechanism to be able to challenge the patent. So ultimately, if there's still a dispute, then that dispute leads to patent litigation in the courts.
So, John, a couple of questions that come in. I think instead of waiting to go to the Q&A, I'll ask them to you right now. The first one is, how often do patent infringement cases happen? As an innovator, how much do I need to worry about this? This seems, kind of scary and expensive. Is it common?
All litigation is costly, so I wouldn't call it common. However, patentees, patent owners certainly have the right to enforce their patent in a court of law. So when you get one of these letters, it's not, it certainly can go down the road of litigation. That's the reason why the dialogue is being opened at that point. There's also probably what people have heard, patent trolls or non-practicing entities. Those are companies that own patents but don't actually produce a device or mechanism or practice their patent, so to speak. They want to, it's not uncommon for them to assert the patent in a patent litigation. So general thought is that, patent litigation is not terribly common because it is a long and expensive process, but patentees are certainly willing to use that as a tool to move forward their patent rights.
Okay, and then the other question, maybe sort of related to reexamination and validity is, this is a great question. I don't quite know how to answer it, so I will leave it to you, John. If a claimed invention is not patentable, how did they get a patent issued from the USPTO or any other patent office for that matter in the first place?
Well, just because it got issued from the patent office doesn't mean it is ultimately a valid claim. Patent office can issue invalid claims. There are a number of reasons why that might happen. One very typical reason, the examiner doesn't have all the information in front of them. Getting a patent is called it's a one-sided situation. There's not two parties. There's just a patent applicant and the examiner. So there could be information that the examiner doesn't know anything about, and so the patent issued, but it shouldn't have issued. Ultimately, the courts have the final say as far as whether a patent's valid or invalid, and that's why a patent that got issued from the patent office may ultimately be found to be invalid.
Okay, so for you out there who think that just because the patent issued from the United States Patent and Trademark Office or the European Patent Office or one of these other patent offices of the world, there are remedies available to you if you believe that the patent should not have issued. Certainly you can challenge that in court, as we'll find out, but also this re-examination thing, which we'll address a little bit more the next time in the next webinar, might help you with that. Okay, so John, I am, we're going to trial, right? So I started the demand letter. Maybe you can talk about what happens next.
Right. So ultimately, if the dispute cannot be resolved, then the patent owner can file a case in a court, and there are different phases to a patent litigation once it gets filed in a court. The first phase is what's called discovery, and we'll talk about all these different phases in the slides coming up. There's the discovery phase, then there's the trial phase, and then after trial, there's a certain period of post-trial where certain information and motions are exchanged, and then ultimately there's an appeal. The median time for a litigation in the United States District Courts, runs about 5 years. This is a median time. There are certainly cases that go quicker, and there are certainly cases that have gone slower than that. Depends on how many patents are being asserted, depends on what court you're in front of. Some courts are just quicker and some courts are slower. The median damages that can occur in a patent case, they've been listed, typically as biotech or pharma, about 20 million, 21.5 million, and medical devices, again, around 20 million. Once again, certainly there are higher awards that have been issued by a court, and there have been lower awards. Depends on the number of patents involved, depends on the number of devices that are involved, depends on how innovative, how much this has impacted the technology in that area. So these are just very general median numbers, but that's about what you could expect. Now, as far as the patent phases of patent litigation, the first one, as I said, was discovery. It occurs after the lawsuit's been filed and before trials. trial, and it generally involves the exchange of relevant information between the parties that are in the case. The things that get exchanged during discovery, the parties collect and produce documents, relevant documents that should be produced in the case. There's depositions that occur, fact witnesses get deposed, and then there's an expert discovery phase where experts for both sides generate a report and submit it to the other side, and those experts are then deposed. And then as you're going up to trial, you prepare exhibits to be used in the trial, you file motions, there could be some hearings that the court hears throughout the discovery phase, and then the court ultimately decides on what the scope of the claim is, and that's called claim construction. And so at some period during, typically during discovery, the court will decide what the definitions of the claim, the scope of the claim, the definition of the terms are.
So just to be clear then, John, the scope of the claim depends on the words of the claim, the words in the specification of patent text you mentioned, the words that the patent owner has said to the patent office while getting the patent, and then the judge's opinion on top of all of this. So this seems pretty complicated. So just sort of give you a sense of how complicated this is, and when I said that the scope of the claim, that red circle, sorry, the white circle with the red boundary was not that straightforward. This sort of gives you an idea of how many pieces are involved. Would that be a fair statement, John?
Yeah, no, it can be very complex and contentious because the scope is important of a claim, and ultimately the parties will submit their positions, and then the court will decide. So it can get very involved.
Okay, so we have our claims. Now we're going to actually trial.
Right. So the next phase after discovery is the trial, and so for patent trials, they can occur in front of a judge only, which is called a bench trial, or in front of a jury, which is a jury trial. Generally, judges, will have a higher level of education than a jury will, and be less emotional as to a story and as to how certain aspects of say an invention, while juries are generally the opposite. Again, this isn't always the case, and certainly there can be very educated jury pool. For example, Northern District of California is very tech heavy, and the tech industry, because of that, has generally very high level of education, so you generally get a higher level of education for the jury pool. So there certainly are exceptions to those kind of general rules. The items that occur during the trial, there's opening statements, then witnesses are presented, and there's direct examination of the witnesses, then cross-examination. Exhibits are used during the trial, so there's entry of exhibits into the official court record. Then closing arguments occur, and if it's a jury, the jury will go back and then deliberate and then render a verdict. If it's a bench trial, the judge will render his opinion or her opinion after all the evidence is entered. Could be months after the closing. It's up to the discretion of the judge. There are also some post-trial motions that typically occur after the close of evidence. So after you move on from the trial, you have several options that exist. So typically after a trial, there's damages that get awarded to the winning side. For a patentee, for a patent owner, there's two types of damages. There's reasonable royalty, and so reasonable royalty is the percentage of profits of the accused device. So if you sold, 1,000 widgets, and the reasonable royalty could be awarded, say, of 3% of the profits of each of those 1,000 widgets. That could be a reasonable royalty. Or there's lost profits. So a patent owner, because they have a patent right and they make their own device, they could have sold, their widgets. They could have sold 100 widgets, but the accused product was out there and it took away 100 sales that the patent owner could have made. So the patent owner can argue, he needs the lost profit of his sales because he would have made that sale if it wasn't for the accused device out there. Beyond damages, the very important tool that the patentee wants to have is an injunction. So you stop the infringer now, because he's found to be infringing after trial. You stop the infringer from performing the patented invention. So you can stop him from making widgets, for example. And as you could imagine, that's a very powerful tool because you shut down a product from a competitor, for example. Parties can always settle at any time, including after trial. And it can occur for business reasons that are wholly unrelated to the patents at suit, or it could be, tied in with the patents at suit, but other business reasons that would make good sense for both parties to settle. And as we'll see in some of the next slides, the verdict that a person gets from trial could be overturned on appeal, or the damages could be reduced, so there is certainly incentive still to settle, even if you have won at trial. Then both sides, the appeal from either side, the losing side, if there's parts of the trial that the one side lost and the other side won, and vice versa, those decisions can be appealed. And the losing side, say the accused infringer, if they're found to be infringing and there's certain damages that were awarded, during the appeal, typically that accused infringer needs to post a bond during the appeal. They may not need to put the entire damages amount to the other side, but they need to put a bond to be able to say if they don't win on appeal, they're good for the money, essentially.
Great. Thanks, Sean. We have a bunch more questions that have come in, so I'll answer one of them myself. The question is, could you describe the inter-parties review process and its implication for biotech patent holders? That's a great question. That is is going to be the focus, part of the focus of next the webinar, the part 2, which is in 2 months. So thank you for that. Now let's see. Okay, so I think this question has already been answered. So what about patent trolls? Do I have to respond to the demand letter? I'll tell what I think the answer is, and John, please correct me on this. I believe you do have to do some kind of response. You don't know a troll is a troll, and even trolls win lawsuits, so I wouldn't do nothing, as John pointed out. It's not a good suggestion to do absolutely nothing. Would you agree with that, John?
Yeah, generally, patent trolls, or as they like to be called, non-practicing entities. They're just like any other patent owner in the sense that they have a patent and it's a property right. So in that respect, they should be treated like any other patent owner, and demand letters or licensing letters should be taken seriously. Great.
And then it says, did you mention where to conduct patent prior art searches, what databases? So I can take that one. The Patent Office has its own proprietary databases. You can access them. If you're physically in Alexandria, you can go to Alexandria or any of the other satellite offices and access them. There are also public search facilities that you can use to access databases. Google Patents actually is a great database, I'll confess, so you can certainly do prior art searches there. You're scientists and innovators, so you probably know a lot of the prior art searches your database sells, Medline, CA+, things like that. So those are all great databases to use. John, here's a question specifically for you. Is there anything you can do if you've informed the CEO and the board of directors of the company that their product, not yet commercialized, is infringing your patent, and they haven't acknowledged that? So you send all your, send the letters, demand letters, cease and desist, whatever it is. There's no indication whether they received the communication or not. What do you do?
Well, you follow up. That's for one. So this is the person who's asserting the letter, is that correct?
Yes. So I guess you are the patentee in this question.
In that question, yeah. You follow up for one, and you certainly can follow up with calls. Ultimately, if the other side is ignoring the letter completely, the tool you always have is to file a lawsuit. You can do that. Now there's issues that go into that, which the next session we can discuss more, but ultimately that is always the strongest tool you have.
Great. So thank you for that. And as John pointed out, in part 2 of this webinar, we will talk about what to do if you're the patent owner. The focus of this one is more as an innovator. Most of the times you're going to be receiving letters potentially accusing you of infringement. So, but that is something that I know people are interested in, and we'll talk about it the next time. So, thank you, and a couple more we'll address at the end. So, John, let's talk about where patent litigation occurs.
Right. So, for patent litigation, there are federal courts, trial courts. They're in the different states. Each state has at least one district. Most states have more than one district. So, with the states, there's 89 trial courts in the 50 states, depending on how many districts there are in a particular state. There's also the United States ITC, the International Trade Commission. It's in Washington, D.C. And then there's also the U.S. Patent and Trademark Office. They have procedures to challenge patents or examine patents after they've been issued. The main office is in Alexandria, right down the street, and they also have satellite offices. After the decision comes from any of those tribunals, it then goes to the appellate courts. The appellate court for patents is the Federal Circuit in Washington, D.C. It's right next to the White House. And then ultimately the Supreme Court, which Supreme Court does not need it. Once the decision comes to the Federal Circuit, the Supreme Court can hear the case. It doesn't have to hear the case. It's called granting of certiorari, and they choose what cases they want to hear, and certainly can hear patent cases. So as far as litigation at trial, so we talked about the U.S. district courts, and you can challenge, we discussed the validity and non-infringement of patent claims in the U.S. and the federal court, the U.S. district court. You can challenge for, prior art or non-prior art reasons. Again, we mentioned one, that the patentee lied to the patent office when they're obtaining their patent, that you can challenge a patent for that. Even if the patent is upheld by the court, you can still get a ruling of non-infringement, which again, invalidity and non-infringement are two important arguments that an accused infringer will make. And if the challenged patent claims are valid and infringed, the patent owner can obtain the money damages, monetary damages, or they can attain an injunction, as we talked about. For the United States ITC, the International Trade Commission, again, you can challenge for the validity and non-infringement of patent claims. However, what you get as an outcome of the ITC is a stop order. It's an order to have the customs offices in the ports to stop goods from coming into the country. That is what the International Trade Commission ultimately can do. It cannot award money damages. So the patent owner is what they're looking for is an order to stop the goods from coming in. They cannot get any money in. Typically, a patent owner almost all the time will file both, a district court case and an ITC case, mainly because you can't get damages in the ITC. You can only get it in the district court.
Yep, great. And ITC cases are becoming more and more important because a lot of the products are being manufactured overseas and shipped over. So as a patent owner, and we'll talk about this more next time, as John mentioned, filing an ITC case is a good thing because you can just stop the stuff from even coming in. So we're done with trial, John. How about appeal?
So the appeal, as we said, it goes to the Federal Circuit. It was actually a court that was created to hear all patent case appeals. So it is the only appellate court that hears patent cases. It hears it from the federal courts, it hears it from the ITC, and hears it from the U.S. Patent and Trademark Office. Now, they do overturn decisions. So, affirmations run about 50%, and they reverse at least part of the decisions about 50%. So it's fairly good chance you're going to get at least some of the decision overturned at the appeal level. Damages, they oftentimes will modify a damage award, and the numbers run about 20% where they'll agree to it and leave it alone, while 80% they will step in and modify it or send it back to the district court level to figure out the better way to calculate the damages. So those decisions from the Federal Circuit can get appealed to the Supreme Court. Again, the Supreme Court doesn't have to hear them. So historically, the Supreme Court has not reviewed patent cases. They typically did not look into them or did not examine them. Lately, there's been more activity at the Supreme Court with patent cases. Some of the recent well-known cases talked about DNA. Genes are generally not patentable, the Supreme Court held, and then computer methods, again, are generally not patentable. So it looks like that the Supreme Court has been pulling back a little bit on patents and causing the gatekeeper, to close the gate a little bit on patents. But with all Supreme Court cases, it's nothing turns on a dime. So it's more general law that needs to go through the courts at that point and come up and get more solidified.
Great. So I just want to reiterate one point that John made, and it's with the Federal Circuit. As you can see, 80% of the time they modify the damages, over 50%, then they reverse at least some part of the opinion. So just because you've lost at trial doesn't mean that that you have to give up the candle. There are options for good appeal, so don't fret. And even if you lose at the Federal Circuit on the case, you might not have to pay very much. And I've seen, I'm sure both John and I have seen cases where they end up paying nothing as a result. Okay, so just a brief teaser about what's coming up next. On Tuesday, November 10th from 2 to 3, we will look at the second half of this, and inter partes review is one of the things we'll look at as to what happens in the Patent and Trademark Office, and something also called post-grant review. I think both of these would be interesting topics for both as a patent owner, but also as a defensive mechanism. And talking about being a patent owner, we can talk about how you put yourself in a very good position for going through the process that John has described. So there are options where you can not bulletproof or gold plate, but really get your patent claims in better condition. If you know of prior art, for example, you can clean up the claim scope. So you have options where you can get nice, stronger patents to take and sue on. Doesn't mean that they can't be invalidated at all, because the federal court system operates independent of the Patent and Trademark Office, but it's certainly one option for you to consider. And we will look at expert witnesses. John told me a couple of days ago that these expert witnesses can make or break a patent trial. So it's a very important topic, and we'll talk about who they are, where they come from, who finds them, who selects them, how do you prep them for trial, and what their effect is on the patent litigation outcome. So as somebody who is an innovator who will be starting companies and who will have patents of their own and may need to end up stopping other people from infringing the work that you put into getting those patents and the technology that you have, this is an important topic to think through. And John and I put together a bunch of resources here that you may want to look into. The United States Patent and Trademark Office litigation website is actually pretty good. There's a general page and a resources page, and this glossary page, which was helpful even to me to talk about some of these terms that I don't use regularly, like patentee and claim scope and elements and so on. So that's helpful to you. The next piece on the left is this Patent Trial and Appeal Board. Most of it, and the re-examination process, most of this we'll deal with next time and be more applicable to what happens next time, because these are the litigation options available at the Patent Office. On the right-hand side top is some websites that give you the Patent Office information on these patents. So if you get a patent number and you want to find out what it is, you want to look into it, you can do it there. Google Patents works as well. You can also find out who the patent owner is, and this is called the assignment information. You can look at the back and forth between the patent office and the patentee, patent owner. So sometimes you'll be able to do that. So you may be able to find statements that they've made that look a little suspicious. You can bring to the attention of the patent attorney, and the patent attorney will do that as well. And there are a bunch of non-patent office links that actually you can find through the patent office website, and that gives you information about whether this patent has been litigated before, other litigation checking features, and litigation search features. You can also look at some statistics on certain types of patents that have been litigated. You can upload your demand letter, and it can do some analytics on that. Some of these are free, some of these are for fee-based. So you can look at them and use them as you see fit, with the disclaimer, of course, that they're non-patent office sites. So, okay, we actually have a little bit of time for a question or two. I have one that's here, and it says, could you please comment on the timing of patent infringement suits with respect to the timing of anticipated revenues or value-enhancing milestones for the claimed product? I'm not quite sure what this is. So are you asking when would these suits be filed against you, perhaps, when you're about to make money? Is that a common thing, John, that I wait as a patent owner or as a troll, and I see a company is just about to make some money or has made some money, and then I go after them? Is that something that happens?
It could. It's certainly part of the overall strategy. There are different factors that could weigh in on timing. One of the factors, as you're raising, certainly could be that. In other words, you'd like to have the company become more robust, and an obvious reason is because there could be more damages out of it, and it could be worth more to negotiate. Because the company won't want to stop a product that's very robust for them as opposed to one that they're starting out with. So that certainly can be a factor. There are other factors too. So timing is, you've got to weigh all the positives and negatives to figure out the timing, but that's certainly one factor that would be weighed.
Do I have any defense against people who have just sort of waited for the right minute just to pounce on me? All of a sudden I'm making money. They could have done it earlier. I mean, that seems sort of nefarious. Is there anything I can do about that? Any defense I have?
There can be. It's called basically resting on your rights. It's the legal term is latches. And there is an argument to say that you could have come earlier and you didn't, so there's a certain portion that you shouldn't be able to get a victory from because you waited and you didn't have to. So that is very fact intensive. So certainly it's a defense that can be used to protect against a situation where they could have got sued 5 years earlier and they didn't.
Great, thank you. So we're just about out of time. I just want to give you some information on how to contact the NHLBI Small Business Program. There are more ways here to contact than I have 2 minutes to talk about. So you can see them all here. And it just remains for me to thank Dr. Chris Asiela, for the wonderful introduction and for setting up the webinar series. She's done a great job, and thank you for that. And thanks to my friend, ex-colleague, John Shu, for his expertise. We'll see him again, obviously, in 2 months. Thank you, John. If you have any last-minute words, you have a minute to do that.
No, not particularly. Thank you very much, Gautam. I appreciate it. And like I said, we gave you a very general overview, and these are the workings. And if you actually get into it, you need to delve more deeply into the situation.
Yes, and this is one of those instances where, as much as you don't want to hear this, I'd say if you get one of these letters and you need to delve into patent litigation, don't do it yourself. You do need a patent lawyer to help you with that. So that's it from our end until about 2 months from now when we look at part 2. Thank you for your time and the questions, wonderful questions. Thank you for them. And we look forward to getting more of those the next time around. So this, we are finished for the evening.